This is my submission, Your Lordship, but it's up to them.
If they are asking for the adjournment, like, I have no objection, Your Lordship.
Then let it come along, Your Lordship.
Can you pass on the order? Mr. Indishula has submitted that this matter is also connected to a related matter pending before the Honorable Supreme Court.
Not related, Your Lordship, is related to those two items, Your Lordship.
Related to
WPC number
matter
465 and then
matter
466, Your Lordship.
listed as matter in WPC 465 of 2021 and also WPC 466 of 2021, and as such it is prayed that this matter may also be adjourned on the same line as was done in the earlier, as was done in the said two cases mentioned above. On pre-made, same is allowed with the on the petitioner appearing through Miss not objecting to the same. As prayed for, this is matter after 4 weeks.
Apply, Your Lordship.
Oblige, Your Lordship.
Yes, Your Lordship. So I beg to make a mention for item 9, Your Lordship.
9 category.
Lordship, I'm praying for a week's time, Lordship.
We have already made it clear the matters to be heard.
Lordship, like senior counsel is having some difficulties, Your Lordship.
Who's Mr. Paul?
Yes, Your Lordship.
2019 matter.
Lordship.
Now it's already what, 5 years or so?
What is, Your Lordship? Then let it come on 30th, Your Lordship, as 30th.
13.
No, 30, Your Lordship.
We'll take it up on 30th then.
Lordship.
What's this?
Mention is made on behalf of the petitioner seeking
9, 10.
accommodation in this matter on the ground that the learned senior counsel Mr. K. Paul, who is handling the matter, is indisposed on grounds of personal difficulties. On premium, the same solo, this is matter on as agreed to by the parties, this is matter on 30th.
13. Your Lordship, next item also will have to go, Your Lordship, but in the next item, that is item number 10, Your Lordship.
With regard to item number 10, Your Lordship, we try to contact the client but couldn't reach Your Lordship. So, if Your Lordship allow, let the notice be issued, Your Lordship, with regard to
Who issue notice? You are the
Then if it's, then it has to be dismissed for non-prosecution, Your Lordship.
So,
if
give
it
us
is-
a week's time, Your Lordship, we'll
if
try
a-
to.
You see, if a respondent is, not appearing, perhaps we can issue notice or by the petitioner. If petitioner is missing, at most we can wait.
Your Lordship.
But then
Then let it come together, Your Lordship, on 30th. If no apparent is made, then
this is matter on 30th.
Lordship. Apply, Your Lordship.
I think it's left then.
Supplementary clause list, item number 1.
Lordship, in this case, Mr. N.J. Datta is taking lead of the case, my lord, and I am instructed to fix the matter on 25th, Lordship.
Not on 25th. It's a bail application.
Yes, my lord.
Yes, Lordship, it's a bail application, and here the accused is in custody since 24th June of 2023, my lord. More than a year.
We'll take it up on 31st then.
31st, my lord.
31st. Lordship. 31st.
On premium by the petitioner, this is matter on 31st.
Item number 3.
Authorised, Lordship.
May it please your lordship. This is the contempt matter, your lordship. Now an appeal has been filed. Now what affidavit I have to file, your lordship? Now lordship direction, only direction, my lord. If third upgradation is due, process it expeditiously, no timeline. That I understand, my lord. We are ready and willing to examine that. If it is due, your lordship.
That is, you see, that I think yesterday we have, we have discussed that
Yes.
issue. The only thing now is if you can give an assurance that the process will be over in 1
No,
month.
we'll
2
examine the
months, 3
matter, my
months.
lord. Because lordship direction is if it is due, we'll process it. Now we need to examine it. We'll examine the entire matter. Give us some time, your lordships. Give us 3 months.
Since 9 months has already lapsed, my lord. So
Give
may
us
not
3
be
months.
2 months maybe given, my lord.
3 months, my lord. I don't want to come back again to the court asking for time. We'll examine the matter, your lordship. Because
In any case, you are already retired.
My lord.
So it will be notional, if at all.
this we have
It
said,
is
my lord,
due
if it
from
is due.
2019, my lord. It
My
is
lord,
due
that is
from
their version, my lord. We'll have to examine it. Because what your lordship has said, if it is due, my lord. So we'll have to examine if it is due or not, my lord.
You should have done that.
Yes.
Why would,
We'll do that.
Why would it take you 9 months to do that?
No, your lordship. That's we'll do it. Because they have filed an appeal also, your lordship.
Forget about the appeal. Appeal is filed just recently.
My lord, it is not if it is due, my lord. It is written
No,
when
no.
he is
Lordship
due.
will-
my
lordship
lord.
will- lordship
My lord,
will-
may
lordship
kindly
will
see
look
the
into it.
judgment, my lord.
Lordship will look into it.
My lord, may kindly see the judgment, my lord.
As and when it is due.
My lord, when it is due.
When it is due. So that we'll have to examine. We'll examine and we'll take a call, my lord. 51.
Age 29, my lord. Para
51.
51.
So, Miss, we'll close this matter.
My lord.
Close it.
Heard Mr. S.N. Leonard, standing counsel for the respondent, contender, Nehu, who has submitted that in terms of the order, in terms of the judgment, dated 31/10/2023, passed by this court in WPC number 44 of 2015, particularly at para 51, the respondent is actively looking into the matter as far as the rights of the petitioner is concerned, that is, with regard to his third financial upgradation. However, the learned counsel would submit that some time may be allowed for the department to complete the process, preferably within a period of 3 months. On such assurance, the learned counsel for the petitioner has agreed that this petition may be disposed of. With direction in this regard, with direction on the assurance respondent. Accordingly, on consideration of the submission made, without going to the merits of this instant petition, the respondent is directed to complete the said process within a period of 3 months from the date of this order, failing which petitioner is entitled to take necessary steps.
Only thing, if I can pray, my lord, instead of, my lord, the process, if your lordship will examine the matter and take a decision.
My lord, that is already been done,
No,
my lord.
this
My
is-
lord
this
has
is-
directed to.
Suppose, my lord, again, because lordship is saying my assurance, your lordship. Now I cannot go to that extent. Lordship, if it is due, my lord, we will examine the matter and take a call.
No, my lord. My lord has come to a
Lordship,
conclusion that my lord,
yes,
third MSAB
Otherwise,
is
your
entitled. He
lordship,
is
my lord,
entitled for third
my
MSAB.
assurance, lordship
third
is saying,
financial
lordship has
obligation,
a record and my assurance, your lordship.
No,
That is not correct.
See, that word,
We'll
see,
examine, we'll
yeah,
examine and
exactly.
take a call.
If it is due, because the word due is there.
Due, if it is due, my lord.
No,
Otherwise,
my
how
lord,
can,
my lord
how
has
can I give
come-
a assurance?
My
your
lord,
lord?
kindly,
Tomorrow university comes and says it's not due.
Direction, my lord. My lord has directed that I am entitled for the third financial upgradation.
As and when it is due.
Due,
My lord.
my lord.
So now
How will decide?
the only determination would be the date.
My lord.
That would be the determination.
My lord.
When you are due.
Yes, my lord.
If it is due to you,
let us
2019
examine.
or 20 or 21, that's up.
My lord,
That's
let us examine and take a call. Instead of process, let us examine and take a call.
but
Because otherwise, tomorrow the question will come. Suppose for some reason they find it's not due, or my lord, whatever has been done.
even if it is not due,
That they
you will
cannot say, my lord.
communicate
It is due.
accordingly.
Exactly, my lord. But then the question will come. I have given, if your lordship, what your lordship has dictated, my lord, I have given an assurance that the process will be completed.
My lord.
Lordship, they only lordship will clarify. This
Mr.
matter will be
Sen,
examined.
What does it mean? Process is completed means process of consideration, process of whether he is due or not.
My lord, I understand.
That is the
I'm
process.
sorry, my lord. If your lordship, my lord, clarify that. If only clarify that. The process of consideration, my lord, that will be enough.
My
your
lord, then,
lordship.
my
The
lord,
process
it
of
will-
consideration.
it will be-
If is well, as of now,
My lord.
if it is found out that he is due and you are not complying or you are not complying with the order,
My lord.
or see, if the matter comes for the second time for this court,
My
No,
lord.
no, no, I'm not saying that. What I'm saying, your lordship is the process of consideration. Only that is.
My lord, if it is go for consideration, my lord, then
It has to
will-
be
it
consideration. My lord, I will not consider.
My lord
University
has
will
already
consider. Lordship
considered
will.
it. My lord has considered it and
Lordship
given a
has when
direction for
dues.
giving the third financial upgradation, my lord. That is the direction, my lord. My lord has already considered and it is entitled for the third financial upgradation, my lord.
Lordship will carry this.
how to? Yang showing itu. Land Council. Complete the process. No. In consideration of the entitlement of the petitioner. What is entitled to you, you will get.
My lord,
That is, see, that is assured. If you are entitled, you will get.
my
You
lord,
very
then
well
they will come with that I am not entitled and all.
Not at all.
that is not that is past.
Sorry. The lordship is closing the matter.
Yes, matter petition dispose of.
From daily list, item number 1.
Lordship, the state has filed affidavit into almost all the case except this item number 3. That is 137 yet to be filed. So 1 week's time may be given, your lordship.
The last time around, you had filed your
We have filed, yes, your lordship.
then
Except 1, that is item number 3.
respondent number 1 to 4. But then here it says that counter has been filed on behalf of the state respondent number 1 to 4. Then, oh, in item number 3. Sorry.
Yes.
Item number 3, Lordship. Item number 3.
Hey, item number 3.
That will be WPC 137, Your Lordship.
1 to 5 are connected matters.
What is the problem here?
Item number 3, Lordship.
Yes, why?
I'll file it in 1 week's time,
Oh,
Lordship.
why? Because these are all similar matters.
Lordship, I have prepared the affidavit, and it's only I need to prepare the copies, extra copies, Lordship.
So we'll list it tomorrow. No?
Tomorrow, day after tomorrow, Lordship, I'll file it during the course of the day.
Mr. H. Karmi, Leonard, additional senior GA, has submitted that the counter affidavit on behalf of the state respondent 1 to 4 is ready. However, the same could not be filed today, and as such, it is prayed that sometime may be allowed for this said counter affidavit to be filed in court as agreed to. On assurance by the Leonard additional senior GA, the counter affidavit is to be filed in due course. This matter on 25th. So 25th.
Yes. Yes, Lordship.
1 to 5 connected, Your Lordship.
The other, as far as item number 1 is concerned, all these
Status filed. Do you also status filed?
So here, as far as the this item is concerned, item number 1, WPC 135, pleadings are complete.
No, Your Lordship, I need to file my rejoinder.
Oh, you have to file yours.
Yes,
Have you done so?
No, Your Lordship. Once I receive the affidavit from 137, Your Lordship, I will file my rejoinder, Your Lordship.
Mr. Leonard Counsel sought for some time to file the rejoinder to the counter affidavit filed by the relevant respondents. As prayed for, this is matter to 2 weeks. Except for the item 3.
Number 3,
The other
Your
will
Lordship.
be
Obliged.
Item number 6.
My lord, I'm praying for 3 weeks to file my rejoinder, my lord. And as also, my lord, in respect of respondent number 2, my lord, he has been suspended and acting chief in his place, my lord. So I may be allowed to implead the acting chief, my lord. He is a necessary party.
respondent number.
Number 2.
Then he is to be struck off.
My lord, as of now, it has to be, my lord, because he has been suspended. He had challenged the suspension also before this honorable court, which was not allowed. Now the matter is pending before the division bench. So, my lord, I may be allowed to strike off number 2 and implead the acting chief in place of number 2.
Yes, so you strike off the respondent number 2.
Yes, my lord, because he's under.
Yes. So in his place,
The acting chief will come, my lord. I'll file the necessary application, my lord.
you file.
As far as the rejoinder is concerned, my lord, kindly grant me 3 weeks.
Mr. S.H. Gautam, Leonard Counsel for the petitioner, has submitted that the rejoinder affidavit may be allowed to be filed within the next date fix, since the same is not yet ready. It is also prayed that an application may be allowed to be filed with a prayer to strike off the name of the respondent number 2 herein and to implead the present incumbent who has been appointed in place of the respondent number 2 as the acting chief.
Acting chief, my lord.
As the acting chief. Pre-meet is allowed. This is matter to 1 week.
Yes, my lord. Will plead.
1 week.
Obliged.
Item number 7.
Your Lordship, I beg to mention item number 7 because the conducting counsel is on sanction leave. I pray for 2 weeks' time.
Who is the
Lordship, the Mr. Sangreso had filed an application for pleading himself as a party. So I have responded to that application.
You file your
So if they're ready to be heard or not.
time.
No, I think the respondent
Respondent number 5.
number 5 is sought for time.
Who's 5?
But the issue here is, Lordship, is only with regard to pleading another party.
5 I think is the complainants, Singh Samla.
Oh. Yeah, counter affidavit.
We have already filed.
By all parties.
Respondent 5 have not yet filed.
Okay, except for respondent 5.
I think they have filed an application for pleading.
Oh, that's a
Because
part.
that has to be heard
that
first,
is-
Your Lordship.
That will be heard first from the main petition. So as far as this main petition is concerned, now respondent 5 has yet to file.
Only 5 left, the rest I have to file my rejoinder too. Because now, Your Lordship, if this Honorable Court finds that the private party, another party is to be pleaded,
Yes,
then they'll file their responses with them.
So,
Bolan licensing. Fix it the after.
Miss Learned Counsel has submitted that the counter affidavit on behalf of the respondent 5 could not be filed today and has sought for some time for the same to be filed. Mr. P. Nongri, Learned Counsel for the petitioner, has submitted that he may be allowed to file the rejoinder to the counter affidavit on the next date, within the next date fix. On the next date, within the next date fix.
In this case, 115, Your Lordship, they file an pleading.
Yes, who's appearing here?
Applicant.
Copy of show cause. Anyway, this application for primary party would be you. You are the only person who can either object it
Your
or
Lordship.
Yes.
Because then
the other concern.
We are not concerned.
they're not concerned. So I'm praying for some expeditious hearing on this application because the entire matter can be heard, Your Lordship. Because whether the inquiry to proceed or not, then Your Lordship will decide accordingly.
I think the inquiry is still.
It's continuing.
It's continuing.
Yes.
It's continuing.
Yesterday also it was there.
Yesterday it was fixed also, Your Lordship.
I think
Because Your Lordship, what has
an order
happened
has
here?
been passed that
It will be subject
the
to
outcome of such proceeding would be.
What in my humble submission, Your Lordship, I'm praying for the expeditious disposal. Why, Your Lordship? Because if, in case Your Lordship finds that the proceedings are illegal, then whatever exercise taken right now, Your Lordship, will be a futile exercise. So that is why I'm praying for an expeditious hearing so that it can be done.
I'm ready, my lord. Otherwise, if he's insisting, I'm ready to hear it today itself.
So he's
Because there are other interveners, Your Lordship, that they have disrupted the entire hearing also.
He's on a strong wicket.
Most probably, but it's for this court to decide.
Ketua miss case mo tu 115
number 115.
Mr. Pinangbri, learned counsel for the opposite party, no, I responded.
Six.
For the respondent. For the respondent. Oblique petitioner has submitted that the show cause to this application for impleachment has been filed. Applicant has submitted that this petition may be heard on the next date. Accordingly, list this matter for hearing after 1 week. Or should we fix a date?
Next week. Yes.
6th or 7th?
6 or 7, any date.
This is matter on 7.
Public.
Ketua Euro 7 more.
Item number 8.
Mr. Sama, this matter was heard?
Yes, Your Lordship, that was heard a long time back, actually, it's last year, on the month of March, it's just part heard.
What is required now?
The case record we have to receive, Your Lordship.
What are the respondents here, Mr. Sama?
Respondents is the Gaurils Autonomous District Council, that is respondent number 1 and 2, and respondent number 3 and 4 are the private respondents here. However, respondent number 3 is not contesting the writ petition.
And who's respondent 4?
Respondent
number 4 have been, the synopsis has been filed.
So you mean to say even the written argument has been filed?
No, it's only the gist of the dates, actually, Your Lordship.
It's like
I have not filed my written argument, it's just the gist of dates. Just the gist of dates and nothing else.
So that we'll know that which way the issue has been decided by the. So now this.
So, Mr. Sama, I think we have to refresh this court.
Yes, Your Lordship, but however, Your Lordship, the respondent number, the counsel for the respondent number 4, the conducting counsel.
He's here.
No, he's busy in the other code, my lord, in code number 2. So, can this matter be taken up?
Who's appearing for?
Mr. S. Dev. S. Dev is appearing. He's having one election matter going on.
You start. Mr. Day is there. He's for the other.
Yes, yes, my lord.
So in the meantime, Mr. Day.
May I please, Your Lordship?
Record as well. You send me. These are one. This is all.
I have already got the copy.
My one, yeah. This one is 1 and 2. My lord, if I can pray, my lord, this matter can be taken up tomorrow, because just now we are exchanging the gist of the argument.
I have no complaints.
No, he can start, my lord, but I will submit it tomorrow if it's possible, my lord.
Maybe that I do not have to do.
Because just now we have received.
Your Lordship,
He has supplied
the
to us
last,
and we have also
I have
exchanged.
submitted long.
We have received just which one?
Lordship, otherwise I can, if I may suggest.
Let him argue, my lord.
My,
We'll see, my lord.
my submissions may be recorded.
Yes, yes. I think we'll see.
If I may begin, Your Lordship. Your Lordship, by this writ petition, the petitioners are wrestling the legality of the judgment and order passed by the respondents number 1 and 2, by which the Nokmaship registration of the petitioners has been cancelled.
Where is the impugned order?
The impugned order is at page 67, which is marked as annexure 12. But if Your Lordship, please, I may just the development which led to the impugned judgment order. So by this writ petition, the petitioners are asserting the legality of the judgment and order passed by the respondents number 1 and 2. This has been cancelled contrary to the law. And the respondent number 4 has been registered as the Nokma of the outcome in question in place of the petitioners in gross violation of law and practice and by resorting to colorable exercise of power. Now, Your Lordship knows that this is a writ petition. So in my humble submission, the only question that requires determination in the instant writ petition is whether the orders passed by the respondent 1 and 2 in cancelling the Nokmaship registration of the petitioners and the subsequent registration of the respondent number 4 as the Nokma of the outcome in question is in consonance with the law. That is the Garwel's Autonomous District Social Customs and Usages Validating Act 1958, which governs all disputes and successions relating to Nokmaship and the outcome boundaries thereof. If I may just, if Your Lordship may permit me to produce the relevant provision of law. The Garwel's Autonomous District Social Customs and Usages Validating Act 1958, it is at page 191 of my book. Yes. Page 191. Yes, I'll read out the relevant portions, Your Lordship. Section 7 and 8 is relevant for the purpose of this case.
Just one. Social customs and usages.
The Garwel's Autonomous District Social Customs and Usages Validating Act 1950. Section 7 and 8 is relevant for the purpose of this case, Your Lordship. I read Section 7. The succession to the Nokmaship of any outcome shall be recognized in accordance with such social customs or customary practice as was followed prevalent in that behalf before the commencement of the Constitution, except that the powers which were exercised by the Deputy Commissioner before the commencement of the Constitution shall hereafter be exercised by the revenue member of the District Council. So it's the revenue member, that is the GHDC, which looks after the cases pertaining to the Nokmaship outcome and the successions and the boundaries thereof. It will be clear from Section 8, Your Lordship. I read subsection 1 of Section 8. Whenever a vacancy occurs in the office of a Nokma of any Akung, or there arises any dispute in the matter of succession of Nokmaship of any Akung, or any dispute with regard to any other matter relating to or connected with any Akung and the boundaries thereof, the matter shall be referred in the first instance to the revenue with the customary practice and the usages of the Garus. Now, the revenue member is the respondent number 2 herein. I read subsection 2 of Section 8. Any person aggrieved at the order of the revenue member under subsection 1 above may prefer an appeal to the chief executive member within 60 days from the date of order. The chief executive member is the respondent number 1 herein, Your Lordship. Now, after the death of the last recorded Nokma of the Akung in question, the petitioners succeeded as the Nokma to the Akung in accordance with the Act by order dated 3/12/2003 passed by the Court of Respondent number 2. If Your Lordship may kindly come to page 32.
Page
32 of my type copy, which is marked as Annexure 4 in series. Page 32, Your Lordship, of my petition.
Yes.
Yes, this is the order passed by the Court of Respondent number 2, registering the Nokmaship of the petitioners, Your Lordship. I read, District GTC number 30, AC of 2003, 2004. Nature of the case, Nokma appointment of Rangmal Grey Akang 3, 28.5. Seen the petition filed by so-and-so for Nokmaship registration of Rangmal Grey Akang, seen also the report submitted by the Mozadar of Mozar number 3 in the statement of clans people and recorded in the separate sheet. The Mahari people in the statement stated that the last recorded Nokma of the said Akang had died long years back, and clans people have decided to register the names of Sri so-and-so and his wife Srimati so-and-so as a Nokma of Rangmal Grey Akang. These are the petitioners 1 and 2 respectively. Now this is important. Since there is no any objector from the clans people during the time of my registration, I hereby declare and register the names of Sri so-and-so and his wife so-and-so Mechek as the successor Nokma of Rangmal Grey Akang 328.5 in the place of late Robin Sangma and his wife Srimati so-and-so with effect from today the 3rd December 2003. Corrected GT and other relevant Akang records accordingly. Hence, by this court's order, the petitioners were registered as the Nokma. Your Lordship, may kindly come to page 34 of my English translation, which is marked as Annexure 4 in series. This is the administration of oath administered to the petitioners by the number 2 as the successor Nokma to the Akang in question.
Yes.
If I may read, Your Lordship. In the Court of Executive Member, IC Land and Revenue Branch, Executive Branch, Revenue Department, GTC Tura, so-and-so, male Nokma, Srimati so-and-so, female Nokma, Rangmal Grey Akang 328.5, dated 3/12/2003. Oath, today the clans members are pleased to appoint me as the Nokma, therefore Rangmal Grey 328.5 Akang Nokma's function shall henceforth be discharged by me. I, being the son in relation and together with the clan members with unity perform the duties towards the Akang and preserve the flora and streams of the Akang, and besides the powers of Nokma vested upon me by the District Council, I shall cooperate with the government, and I give this in writing before your honor on this the 3/12/2003 at 1:15 p.m. with my thumb impression thereto. LTIF male Nokma, LTIF female Nokma. Your Lordship, soon after they were registered as Nokma. Now 3 months after passing of this order dated 3/12/2003, and after the administration of oath, 3 months after passing of this court's order, the respondent number 3 filed a fresh application to register the petitioner number 2 again as the Nokma of the Akang in question before the court of respondent number 2. Now, pursuant to the application filed by the respondent number 3 to register the petition number 2 again as the Nokma, an inquiry was conducted to the effect, and on completion of the inquiry, report was submitted. On submission of the inquiry report, the inquiry officer apprised the court of respondent number 2 that the petitioners had already been registered as the Nokma of the Akang by the predecessor of the court of respondent number 2. If your Lordship may kindly come to page 46 of my petition, which is of my type copy, which is marked as Annexure 6 in series.
Yes.
This is the report submitted by the Mozadar, by the inquiry officer, and apprising the court of respondent number 2 that the petitioners had already been registered as a Nokma. It says, report submitted by the Mozadar in connection with the Nokmaship registration of Rangmal Grey Akang may please be perused. It is to point out that the Nokmaship of Rangmal Grey Akang has been appointed by a predecessor IC Land Revenue on such and such date, but after the appointment there is raised some objector from the clans against the registration of Sri so-and-so and his wife so-and-so. Parties are praying to take step, put up for your order. Your Lordship, here, the plain reading of the report makes it amply clear that the earlier registration of the petitioners as Nokmas of the Akang in question is brought to the knowledge of the court of respondent number 2. However, the respondent number 2, instead of calling for the case records to verify the authenticity of the court's order registering the Nokmaship of the petitioners, chose instead to issue summons to the petitioners. I read, Paris inquiry report submitted by still Mozadar number 4 of Sri so-and-so issues summon letter for both the parties for appearance in my court. Can you note the order? The order to issue summons was passed on the 24th of August 2004. However, summons was issued only 3 years later from the date of this order. If your Lordship may kindly come to page 48 of my petition, of my English translation, which is marked as Annexure 6 in series.
Yeah.
This is the summons. I read the Court of Executive Member, IC Land and Revenue, Garo Hills District Council, Tura, GDC number such and such, dated Tura the 1st March 2007. Kindly note the date, Your Lordship. It is 3 years from the date of the order dated 24/8/2004. Sri so-and-so, petitioner versus so-and-so, opposite party. Subject, summons. This is to officially inform you that with regard to the dispute relating to appointment of Nokmaship of Rangmalgiri 328.5 Akang, you are to appear before this Honorable Court on 7/3/2007 at 11 a.m. Your Lordship, on receipt of the summons, in any case of the matter, the petitioners entered appearance and filed a show cause stating that they had already been registered as the Nokma of the Akang in question and need not be registered twice.
Yes.
Now, at this juncture, the respondent number 3, having received the show cause filed by the petitioners, filed an additional application before the court of respondent number 2 without seeking the leave of the court and without supplying the copy of the same to the petitioners. And new adverse facts surfaced contrary to what was prayed in the pleadings. The respondent number 3 in his additional application stated that the application for Nokmaship registration filed by the respondent number 3 was actually meant for the Nokmaship registration of the respondent number 4 and not the petitioner number 2. Thereafter, the petitioners to file an additional application before the court of respondent number 2 and again apprised the court of respondent number 2 that they had already ordered dated 3/12/2003 passed by us as the Nokma of the said Akang, the respondent number 2, in colorable exercise of power, without any jurisdiction vested upon him to review the matter, arbitrarily proceeded to adjudicate the matter and passed the impugned judgment order dated 23/8/2016, thereby cancelling the Nokmaship registration of the petitioners in blatant violation of the Act. If Your Lordship may kindly come to page 67,
Yes.
which is marked as Annexure 12. Page 67, this is the impugned judgment and order passed by the court of respondent number 2. I
23/8/2016.
Yes, 23/8/2016. I read, in the Court of Executive Member, Garo Hills, Autonomous District Council, Tura, dated Tura, the 23rd of August 2016, number GHADC, Revenue 33 AC 2004. Sri so-and-so, petitioner versus so-and-so, opposite party. Judgment and order dated 23/8/2016. The present case came up before this court challenging the registration of Sri so-and-so and his wife Srimati so-and-so, Marak as Nokma of Rangmalgiri 328.5 Akang. The petition for registration of Sri so-and-so and his wife Srimati so-and-so was moved by Sri so-and-so, being the Tra of Chambugong clan of Rangmalgiri. On receipt of the petition, a report was called from Hill Mozadar of Moza number 3 to ascertain as to whether the claim made by the petitioner is correct. Hill Mozadar of Moza number 3 submitted his report before this court, being dated 18/11/2003. Based on the said report, a date was fixed, and accordingly Sri so-and-so and his wife Srimati so-and-so are being recorded as Akang Nokma of Rangmalgiri 328.5 on 3rd December 2008. Meanwhile, another petitioner under Section 7 and 8(1) of the Garo Hills Autonomous District Social Custom and Usages Validating Act 1958, dated 24/3/2004, was received from Sri so-and-so, that's the respondent number 3, son of so-and-so, for recording the name of Srimati so-and-so as Akang Nokma of Rangmalgiri 328.5. It may be mentioned that the same name of Srimati Winjis Marak has already been recorded on 3/12/2003, and as such, there is no reason why there should be another petitioner for recording the name of the same person, again as a Nokma of the said Akang, unless there is some bona fide mistake. Your Lordship may kindly take note that the plain reading of the first 2 paragraphs of the impugned judgment order makes it crystal clear that the respondent number 2 was well aware of the previous order dated 3/12/2003, passed by the same court registering the Nokmaship of the petitioners. I continue. Sri so-and-so, C.H. Marak, has filed petition under Order 1, Rule 10, read with Order 6, Rule 17, and Section 153, CPC, for amendment of his petition dated 24/3/2004. On the ground, amongst other, that due to bona fide mistake, the name of Srimati so-and-so, Marak, has been wrongly written as so-and-so. All other contents of his petition refer to Srimati only, name of a mother, father, etc. Order 1, Rule 10, CPC reads, where suit has been instituted in the name of the wrong person is plaintiff or where it is The court may at any stage of the suit, if satisfied that the suit has been instituted through a bona fide mistake and that it is necessary for the determination of the real matter in dispute, so to do any other persons to be substituted or added as plaintiff upon such terms as the court think just. Or the 6th Rule 17 of CPC says the court may at any stage of the proceedings allow either party to alter or amend his pleadings in such manner and or such terms as may just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions and controversy between the parties, provided that no application for amendments shall be allowed after the trials has commenced unless the court comes to the conclusion that in spite of due diligence, the could not have raised the matter before the commencement of trial. This provisions of law will speak for itself that the court may at any stage of the proceeding and for the purpose of determining the real question in controversy between the parties allow amendment of the plain petition. It transpired from the petition of Sri So-and-so, Marak the Trop Chambung clan of Rongalgre Akeng, that if his petition really meant and referred to Srimati Funji Marak for registration of Nokma, then the first registration done on 3/12/2003 was apparently without the knowledge of the Chambung clan of the Akeng. On the other hand, if the name of Funji was with bona fide mistake, as all other contents with name of parents late Rabhan Sangma and his wife late No Sing C.H. Marak refers to the parents of Srimati C.H. Marak, as mentioned in the amendment petition of the petitioner, it will be miscarriage of justice to disallow the petition for amendment. The amendment petition, therefore, is accordingly allowed. Can you note here, Your Lordship, that the amendment petition filed by the respondent number 3 was rejected by order dated 14/6/2012. If Your Lordship permits
so this
me,
is the same petition?
This is the same petition, Lordship.
It was not allowed, now it is allowed.
If I may, Your Lordship, produce one citation. It's just a citation which I have placed before, Your Lordship. I'm relying on the same citations, Your Lordship. AIR 1967, SC 96. Yeah, AIR 1967.
Go through the facts first.
Facts, okay. If I may continue, Lordship.
Please.
Coming to the next question, it is essential to know who was the last recorded Nokma of Rangmalgra Akeng 3 and how the contesting parties are related to the last recorded Nokma. To determine the contesting parties as how they are related to the last registered Nokma of the Akeng, it is sufficient to trace the last two generations of Nokmas as recorded in the Ambi genealogical trees of Rangmalgra Akeng 328.5. Late Gatran Sangma and his wife, late Watmi C.H. Marak Mechek, were the registered Nokma prior to the last recorded Nokma. Late Rabban Sangma and late Nosing Marak as per genealogical tree. The inquiry report dated 7/6/2004 submitted by Hill Moser number 4, which was conducted on reserve of complaint after the registration of Sri Diwan Sangma and his wife, Srimati Winji C.H. Marak as Nokma. From the petitioner, late Gongri C.H. Marak as the Nokma daughter of late Gadran Sangma and his wife, late Patmi C.H. Marak Mechik. But when she was still younger, her name has been recorded as Nokma along with her parent. Rabban Sangma was given marriage to Srimati Gongri Marak and recorded his name as Nokma along with Gongri Marak, but unfortunately Gongri died in a very tender age who was not fit to conceive, and due to which she did not bear any issues. After that, Gongri Marak, Srimati Nosing Marak was given by the Chambung Mahari after consensus decision as substitute wife to Rabban Sangma, and her name has been recorded as Nokma along with her husband Rabban Sangma. Srimati Nosing C.H. Marak died in the month of May-June 2003, but her husband died 9-10 years. As per the statement of both the parties recorded during the Mozita re-inquiry report dated 7/6/2004, it was admitted by both the parties that beside the son, namely Sri So-and-so, who is still alive, Srimati So-and-so is the only daughter of late Rabban Sangma and late Nosing C.H. Marak, the last recorded Nokma of Rangmalgra Akeng. The only ground of the defendant praying for objecting Srimati Wichi Marak is that late Nosing Marak is the mother of Srimati Wichi Marak, was not offered by Mahari as substitute wife to late Rabban Sangma, but she looked him as a husband on her own accord without the consent of the Mahari, and therefore her daughter, Srimati Wichi Marak, is not entitled to become the Nokma of the Akeng. It is hereby noticed that the parent of Srimati Winji C.H. Marak is Srimati late Rakchi Marak and Sri Rahman Sangma, whose names has been registered and recorded in the genealogical tree of Nokmas of Rangmalgra Akeng. But it is noticed that while registering Srimati Winji Marak and her husband Diwan Sangma, they are believed and being placed as daughter of Srimati Nosan Marak and Sri Raban Sangma, which is presented by suppressing the actual fact. The Nokmaship as per Garo customary law is through the lineage of mother to the Nokma daughter or other daughters of the last recorded Nokma. And if there be no female issue, then the matter shifted going to for adoption of a daughter through the nearest female lineage. As in the present case, at hand the true picture has been distorted by depriving the rightful legal heir by misrepresenting a wrong person to be the Nokma daughter of the last recorded Nokma of the Akang. Therefore, the registration of Srimati Winji Marak and her husband, Sri Diwan Sangma, as Akang Nokma of 328.5 Rangmagre has been done to misrepresentation and suppression of fact and not as per the customary practice and usages of the Garos. I hereby do stand cancel the registration of Srimati Winji Marak and Sri Diwan Sangma as Nokma of Rangmagre 328.5 Akang. Accordingly, petitioner is allowed, no order has been passed as to cause case stands dispose of. Your Lordship, now here in my humble submission, the respondent number 3 has invoked, actually it has no power to, the Act does not prescribe the power to review, and hence he has passed his order without jurisdiction. Regarding that jurisdiction, Lordship, if I may produce one citation. 1971, 3 SCC 844. 1971, Volume 3, SCC 844. If I may read out the relevant portion, Your Lordship. This more paragraph. Paragraph 4, Your Lordship, which is at page 4. It's a small line, Your Lordship. 6 lines from the top, Your Lordship. Paragraph 4, 6 lines from top. It is well settled that the power to review is not an inherent power. It must be conferred by law, either specifically or by necessary implication.
Just a moment. This is not the 1971, isn't it?
Yes, 1971, 3 SCC 844.
Para 6.
Paragraph 4, Your Lordship.
Para 4.
Paragraph 4, which is at page 4. 6 lines, Your Lordship, from the top. 6 lines. It is well settled that the power to review is not an inherent power. It must be conferred by law, either specifically or by necessary implication. The Act does not prescribe the power to review, Your Lordship.
Yes.
Your Lordship, it is to be noted that the order registering the Nokmaship of the petitioners, that is ordered at 3/12/2003, can only be set aside on grounds of being illegal or contrary to law by the court superior to the court which passed the order, and not by the same court. In my humble submission, Lord, it is an accepted principle of law that when a matter has been disposed of by a court, the court is, in the absence of a direct statutory provision, functus officio and cannot entertain any fresh prior application with regard to the same subject matter unless and until the previous order of final disposal by the superior court. It is an accepted principle of law that the power to review is also an inherent, it's not an inherent power, but must be conferred by law, either specifically or by necessary implication. Now, since such exercise of jurisdiction tantamount to gross judicial impropriety and indiscipline, Your Lordship, the cancellation of Nokmaship of the petitioners was uncalled for and unwarranted. Now, aggrieved by the said impugned judgment and order, that at 23/8/2016 passed by the Court of Respondent number 2, an appeal was preferred under section 8.2 of the Act before the Court of Respondent number 1, who, after hearing the parties and without determining the genuineness of the case, dismissed the appeal by impugned judgment order dated 23/3/2018. If Your Lordship may kindly come to page 84 of my type copy, which is marked as Annexure 15A, this is the impugned judgment and order passed by the respondent number 1. I read, in the Court of Chief Executive Member, Garo Hills Autonomous District Council, Tura, JHDC. Revenue Appeal number 9 of 2016, Sri so-and-so versus so-and-so and so-and-so. Judgment order. This incident appeal is against the order dated 23/8/2016 passed by the Learned Court of the Executive Member, IC Land and Revenue, wherein after referred as EM, passed in Revenue Case number 33 AC of 2016 under Section 82 of the Garo Hills Autonomous District Social Customs and Usages Validating Act 1958. The brief facts of the case are that Meng Seng CH Marak in the year 2003 filed an application before the executive member IC Land and Revenue for registering the name of Winji CH Marak as successor Nokma after death of last registered Nokma, namely Nosing Marak and Raban Sangma. Based on this said application of Meng Seng Marak, the learned EM had directed the Mozada to conduct inquiry and submit a report. As per the said order, the Mozada submitted its report dated 18/11/2003 before the learned EM, and accordingly Sri so-and-so and his wife Srimati so-and-so are being recorded as Amal Grade 3285 on 3rd December 2003. Your Lordship, kindly note here, to the respondent number 1 was very much aware of the order dated 3/12/2003 registering the membership of the petitioners. I read. After Sri so-and-so and his wife Srimati so-and-so were recorded as Akung Nokma from Malgate 3285. Another petition under Section 7 and 8.1 of the Garo Hills Autonomous District Social Customs and Usages Validating Act 1958 was filed on 24/3/2004 by Sri so-and-so for recording the name of Srimati so-and-so as Akung Nokma from Malgate 3285. The issue which was before the learned EM was that the name of Srimati Winji CH Marak has already been recorded on 3/12/2003. And as such, there is no reason why there should be another petition for recording the name of the same person again as Nokma of the same Akung, unless there is some bona fide mistake. The matter before the learned EM was that Sri so-and-so had filed petition under Order of 1, Rule 10, read with Order 6 and Section 153, CPC for amendment of his petition dated 24/3/2004 on the ground mentioned below that due to bona fide mistake, the name of Sri so-and-so has been written as Winji CH Marak, that all other contents of his petition refers to Srimati Wachi only, with his name of her mother, father, etc. As part of finding of the learned court before late so-and-so and his wife, late so-and-so, may check were the registered Nokma prior to the recording of the last recorded Nokma, namely late Raban Sangma and late Srimati Nosing Marak, genealogical tree of the said Akung Nokma. The re-inquiry report dated 7/6/2004 submitted by Hill Mozart number 4, which was conducted after the complaint was received and after the registration of Nokma, namely Sri Diwan Sangma and his wife Winji CH Marak. Further submission of the Learned Council in length, perused the original records and other relevant documents. This court found that as per the statement of both the parties, which was recorded by the Mozada on his re-inquiry, wherein it was an admitted position of both the parties that beside the son, namely so-and-so, who is still alive, Srimati Waji CH Marak is the only daughter of late Sri Raban Sangma and late Nosing CH Marak, the last recorded Nokma from Malgre Akung. While registering the name of and her husband Diwan Sangma, they believe in being placed as daughter of Srimati Nosing Marak and Sri Raban Sangma, which is presented by suppressing the actual fact. As per the Garo customary laws, the Nokmanship is through the lineage of mother, which goes to the Nokna daughter or to any other daughter who are jointly selected by the mother and father, or only by the mother or by the Tra of a Machong. And if there are no female issue, then the question of adoption of a daughter comes through the nearest female lineage. In the present case at hand, the true picture has been distorted by depriving the rightful legal heir by misrepresenting a wrong person to be the Nokna daughter of the last record Nokma of the Akung. In the instant case, since the registration of Srimati Winji CH Marak and her husband, Sri Diwan Sangma, as Akung Nokma of 3285 from Malga Akung, has been done by misrepresentation and suppression of fact, which is totally against the customary practice and usages of the Garos, and the same is not permissible. The Akung land is also subject to the ordinary laws of inheritance through the system of Nokna and Nokrom, who are entitled to succeed to the Akung, and they shall be recognized as Noknas by the JHDC. When they succeed, their names are entered in the record of the District Council. Formerly, the records were of the Deputy Commissioner. The real owner is the wife, but for practical purpose, the husband is spoken of as the proprietor, and Nokma is a person who holds title to the Akung land of village community as head of the clan. A particular clan to claim for Akung must know the origin of the Akung and must perform the duties of the Nokma without any break. I am satisfied that there is no irregularity in the order dated 23/8/2016 passed by the learned EM in GHADC such and such 2004, and I hereby appeal the said order dated 23/8/2016. For the aforesaid reasons, I find no merits in this instant appeal herein, and the same is dismissed with no order as to cause. The parties shall bear their own cause. Your Lordship, now in my humble submission, the authorities below has passed the impugned judgment and orders with an intention of extending illegal gain and undue favor to the private respondents. The authorities below, that is the respondent 1 and 2, has ignored the very fact by looking the other side that the Nokmaship registrations of the petitioner was made after following due process of law and custom, and the same could not have been cancelled under the Act, as there was no provision under the Act to reopen or review any matter which was already disposed of under Section 8.1, except by preferring an appeal under Section 8.2 of the said Act. Now, the correct remedy for the respondent number 3, if he had any grievance against the registration of the Nokmaship of the petitioners, that is the order dated 3/12/2003, was to approach the court of respondent number 1 within 60 days from the date of the order. Yes. And not institute a fresh suit against in the same court. Hence, the impugned judgment and orders passed by the authorities below, that is the respondent 1 and 2, are ultra-virus, illegal, and unjustified, and suffers from a patent error, and should be set aside and quashed on grounds of it being permissive in law. Your Lordship, if I may just, if Your Lordship may permit me to refer to my rejoinder. Your Lordship, my rejoinder affidavit is the result of the additional affidavit in opposition filed by the respondent number 4.
Yes.
In the affidavit in opposition filed by the respondent number 4, there was a typographical error in the name of the deponent. The same had been corrected with the leave of this honorable court. However, the respondent number 4 took the liberty to amend the petition, changing the nature of the pleadings, contrary to what was pleaded in the previous counter affidavit. If Your Lordship may permit me to read out paragraph number 4 of my rejoinder, which is at page 4.
Dated?
Paragraph 4.
No, your rejoinder was filed on
11 July 2023.
July.
Yes, Your Lordship.
Respondent 4. Yes.
Paragraph 4, which is at page 4, Your Lordship. If I may read, Your Lordship. That before making a paragraph's reply to the aforesaid subsequent additional affidavit in opposition dated 24/2023, filed by the respondent number 4, at the outset, it is respectfully stated that this honorable court, via order dated 9/3/2023, has permitted the respondent number 4 to make corrections, particularly with regard to the actual correct name of the deponent, and also in some parts of the amendments which had occurred in the original affidavit in opposition dated 39/2019, filed by the respondent number 4 as a result of a typographical error. However, it is pertinent to mention herein that in the subsequent additional affidavit in opposition dated 24/2023, filed by the respondent number 4, the said respondent, though has corrected the name of the deponent, has changed the character nature of the original affidavit in opposition, resulting in the travesty of justice, inasmuch as the respondent number 4 has amended her amendments contrary to what was actually stated in her original affidavit in opposition dated 39/2019. Hence, the said subsequent additional affidavit in opposition dated 24/2023, except for the corrected name of the deponent, cannot be relied upon as an affidavit in opposition for adjudication of this instant matter. Therefore, the petitioners herein praise that this honorable court, save for the typographical error of the name of the respondent number 4, which has been corrected in the subsequent additional affidavit in opposition dated 24/2023, the original affidavit in opposition dated 39/2019, filed by the respondent number 4, be taken up, considered for the proper adjudication of the instant writ petition in the interest of justice. Now, Your Lordship, basing on this prayer made by the petitioners, a prayer was made by the respondent number 4 to file a fresh affidavit by withdrawing their earlier affidavits, which was not permitted by this Honorable Court by the order dated 31/10/2023, and this Honorable Court opined that the matter be heard on merits. If your Lordship may kindly come to paragraph 14 of my rejoinder, which is at page 8. Your Lordship, this may require comparative reading of the earlier affidavit in opposition, Your Lordship, of the respondent number 4.
Yes.
Paragraph 14, page 8,
Yes.
if I may read. That the averments met in paragraph number 12 of the affidavit in opposition is non-specific, vague and devoid of any merit. In reply thereto, the petitioners reiterate the averments made stands taken by them in paragraphs number 11 to 15 of the writ petition. Moreover, it is worth mentioning herein that the respondent number 4, in the paragraph under reply, has omitted the following words, and a sister annices of the last recorded and registered Nokma Michek, which is part of the original affidavit in opposition dated 39/2019 filed by the respondent number 4. Lords, these are the words which I have reflected here. This is missing in the subsequent additional affidavit in opposition, Your Lordship. Perhaps Your Lordship may find it more interesting if I go on with the other paragraphs, Your Lordship. Paragraph 15, Your Lordship, which is at page 9. That the averments met in paragraph number 13 of the affidavit in opposition is non-specific, vague, and devoid of any merit, and the petitioners reiterate the averments met stands taken by them in paragraphs number 60 to 20 of the writ petition. The respondent number 4 herein has amended the paragraphs under reply by stating only half of the paragraph under reply, that is by ending her averments in the words towards the residence of the account, and omitting the words in the sentence which followed thereafter, which was in the original affidavit in opposition, dated 39/2019 filed by the respondent number 4. If Your Lordship may kindly refer to the original affidavit in opposition filed by the respondent number 4, dated 39/2019. That would be if I may take Your Lordship to paragraph 13 of their affidavit in opposition, which is at page 4.
Yes.
Paragraph 13 of their affidavit in opposition, dated 39/2019. I read. Lordship, they have replied to the averments made in paragraph 16 to 20 of my writ petition, Your Lordship.
Yes.
So, if Your Lordship may permit me to just highlight those averments which I have made in my writ petition in capsule form, Your Lordship.
Yes.
In paragraph 16 of my writ petition is with regard to the written statement filed by the petitioners, bringing to the knowledge of the Court of Respondent number 2 that they have already been registered as a NOCMA and need not be registered twice. In paragraph 17 of my writ petition is with regard to the private respondent number 3 filing rejoinder, bringing in new facts contrary to the main petition. In paragraph 18 of my writ petition, we have prayed for dismissal of the petition filed by the private respondent number 3 before the Court of Respondent number 2. Paragraph 18 of my writ petition is with regard to suggested issues filed by the parties, and paragraph 20 of my writ petition is with regard to the belated amendment petition which the respondent number 3 have filed. If I may read, Your Lordship, now that the statements made in paragraph 16 to 20 in the writ petition, the deponent begs to state that the petitioners must be able to prove the NOCMAship with documents and proper reasons, but in the instant case, the petitioners were unable to do so. Moreover, the NOCMA must perform the duties of NOCMA towards the residents of the Arkham. Now, they have stopped here, Your Lordship, in the additional counter affidavit. From the words, however,
yes,
it has gone missing. And they have a reason why, Your Lordship, if I may read. However, in the instant case, it was not done by the petitioners. In the instant case, there is no document on record to show that Srimati Nimji Armara and Sri Arbinath Sangma were appointed as temporary NOCMAs of 451 Wakso Akang on behalf of the petition number 1. Your Lordship, here I would like to mention that the submit here. The subject matter here is the illegal cancellation of Nokmaship of Romalgre Akang 3285 located in West Garrels district. Now, who is this Nemji R. Marak and who is this Arbinit Sangma and where is this temporary Nokmas of 451 Wokso Akang is coming? We do not know, Your Lordship. It is to point out that Srimati Nemji R. Marak and Sri Arbinit Sangma were duly appointed and registered as Nokmas of 451 Wokso Akang, and after the appointment, no one has challenged the appointment as Nokmas of the said Akang. If I read paragraph 14, Your Lordship.
When were they allegedly appointed?
The petitioners
No, these two.
This Arbina Sangma, Your Lordship. This is strangers to the case, Your Lordship.
No, they said that they have been appointed as temporary Nokma.
It has got Lordship.
No, just the yes.
In all fairness, Lordship, the original affidavit was filed in 2019. For some inadvertent mistake, Lordship, by the council, two cases were mixed up in the same affidavit, which is why the names of a different came. Which is why I, after entering appearance, after taking up the matter, Lordship, I prayed that I may be allowed to correct the affidavit. And in the corrected affidavit, I have just omitted those parts which were not part of the and the name. So I have not added any submission. I have just removed the parts which were not relevant.
So
In fact,
these are not at all involved in this.
No, Your Lordship, not at all. That is why. But the thing is that they have actually given in the affidavit.
They will also not press for this.
Lordship, they prayed to the court, of course, Your Lordship, that they wanted to change all. But however, they came after a very long time again, Your Lordship. It is not done immediately.
That is a different thing.
Yes. And same thing with the paragraph 14, Your Lordship. Here they have mentioned the same thing and they have not answered to any of the averments, Your Lordship. In fact, they have not answered to any of my averments, Your Lordship. Your Lordship, if I may just press the court, if I may take Your Lordship to paragraph 7 of their affidavit in opposition, Your Lordship, which is at page 3. It won't take much time now, Your Lordship, and just a few more minutes. That the statement made in paragraph 2 of the writ petition is a matter of record and the deponent has no comment. Here, Lordship, in my writ petition, I have stated that the respondent number 4 has been registered as a NOCMA in gross violation of law and practice and by resorting to colorable excesses of power. Here, no comments. Again, like they have admitted to the fact that the respondent number 4 has been registered as a NOCMA in gross violation of law and practice. Now, in paragraph number 9, that the statement made in paragraph 5, 6, and 7 of the writ petition is totally false. In paragraph number 5 of my writ petition, I have stated that Akang belongs to Chambugang clan. In paragraph 6, I have stated my lineage and the genealogical tree. In paragraph 7, I have stated that the Garrels Autonomous District Council is a constitutional authority constituted under 6th schedule of the Constitution of India. She has stated that it is false. And that is paragraph number 11, Your Lordship. That the statements made in paragraph 9 and 10 of the writ petition is totally false. Here, Your Lordship, I have stated that the respondent number 4 is that Nosing Marak is the mother of respondent number 4. Yes, it's not true. They have answered to none of my averments, Your Lordship. It is my supposition, Your Lordship, that this honorable court may interfere with the impugned judgment order, Your Lordship. I raise my supposition, Your Lordship.
May I please, Your Lordship? I will just give a short summation of what my lord, and my lord, I will counter tomorrow, my lord, with judgments, my lord, and with the record, my lord. Now, the true issue which has to be decided by this honorable court is this, my lord, that whether the tribunal or a quasi-judicial authority can also take the spirit of the CPC. Can they also follow the spirit of the CPC by a quasi-judicial authorities or a tribunal, my lord? Can they do or not, my lord? My friend has tried to project a case that a court which pass an order or a quasi-judicial body which pass an order, and if the act is silent on the review provision, whether review can be made or not. I will place the authorities, my lord, on those, my lord. Second thing, my lord, what is the locus of the petitioner to come before this honorable court? Now, wrongly, rightly, the petitioner's name was entered in the genealogical tree, my lord, by the order of the EM, my lord. But by suppressing the fact that whose daughter and son They are, my lord. The son-in-law and the daughter. My lord, may kindly come to the order. Page 71. I'll just highlight few facts, my lord, and then tomorrow, my lord, I'll continue my submission, my lord. Page 71 of the writ petition, my lord.
Yes.
Now, my lord, may kindly see para 2, my lord. It is hereby noticed that the parents of Winji is the petitioner, my lord. Winji C.H. Marak is Srimati late Rikji Marak and Sri late Rakman Sangma, whose name has never been registered and recorded in the GT of the Nokma of so and so, my lord. Aking. But it is noted that while registering so and her husband Diwan Sangma, that is a petitioner, both the petitioners, they are believed and being placed as a daughter of Nose Marak and Raben Sangma, which is presented by suppressing the actual facts. My lord.
Yes.
Now, my lord, may kindly skip the next para and my lord come to the last para. Therefore, the registration of Winji, the petitioner number 2, and her husband, the petitioner number 1, as Aking Nokma of so and so has been done to misrepresentation and suppression of facts and not as per the customary practice and usage of the Garos, my lord.
Yes.
Now, my lord, may kindly see that what is the locus of the petitioner for getting registered as a Nokma, my lord. Even though the EM and CM was silent on that part, but they try to justify it by giving this finding, my lord. Now, my lord, may kindly see the writ petition. The writ petition para 6, my lord.
Yes.
That the petitioner number 2 belongs to the Chambongan clans and comes from the lineage of the genealogical tree of so and so Aking Nokma family. The petitioner number 2 is the biological daughter of so and her elder sister of so and so female, who were both daughters of the then so Aking Nokma, that is Getran Sangma and Watmi Marak Michik, and as such the petitioner is the granddaughter of so and so, my lord. Now, my lord, if they was the granddaughter, my lord, then why their name has not been inserted when the last recorded Nokma died, my lord? My lord, may kindly see the Annexure 1, page 24.
Yes.
Now, my lord, may kindly see the Nokma GT, which has been enclosed by my learned friend Wanjang Sangma and Geti Marak Michik, my lord.
Yes.
Michik is the lady, my lord. Now, the next Nokma is Getran Sangma and Watmi Marak Michik. That means Getran Sangma's wife is Watmi Marak, my lord, is the first wife. The second wife from whom they are claiming the Nokmaship, my lord, they are claiming, whose the Nokma is presently, the daughters is the present Nokma, my lord. Now, my lord, if the third wife doesn't have the right over the Nokma,
Where's the name of the third wife is not here.
no, it is there, my lord. Nosi Marak.
Nosi Marak?
Yeah, N-O-S-I-N-G, Nosing Marak.
Nosi Marak is the third wife or wife of Raben?
No, it was the first third wife, my lord, and then Raben was given, my lord. Raben Sangma.
No, this is not clear. You see, here,
Yes, my lord.
you look at Raben Sangma,
Yes, my lord.
then opposite the name of Nosing Marak is there.
Yes, my lord.
Which means that she is the wife of Robin.
Yes,
But you say that she is the third wife of Gathram.
it was given because they used to give a proposed name, my lord. Like who will be the next wife, my lord. And then the man comes. Like for example, my lord, if Sujit De is having a first wife has no issue, second wife also no issue, my lord. Third wife is given. Now, my lord, third wife may not be a biological wife of mine. May not be a biological wife. It's just to place someone, my lord, so that the Nokmaship doesn't fall vacant, my lord. May not be a biological wife of mine. The biological wife of Rabin Sangma. From Rabin Sangma, she has those issues, my lord. And they are the present Nokma. My lord, that is why, my lord, what I was saying, my lord, that I will submit it tomorrow, my lord, along with the record. We'll place all the documents before this honorable court to show that they have no locus itself, my lord. Because, my lord, their name, their father and mother's name has never been proposed, never been recorded, my lord. Now, they are saying that no, we are the granddaughter of the last recorded Nokma. If that is the case, my lord, where is the petition by which they are claiming? Why they have suppressed the fact that they are the daughter and father of some other parents, my lord? Why they have not mentioned? Why they have mentioned the name of Raben and Nose for obtaining the Nokmaship, my lord? Now, again, my lord, coming back to the second question, that whether review is permissible or not, that I have to satisfy the judgments, my lord.
We will continue tomorrow. I see. We'll take it up day after tomorrow. So,
Yes, Your Lordship, please.
heard Mr. Sangma, learned counsel for the petitioner, who has concluded his. Then I have also heard Mr. ND, learned standing counsel for the respondent, GCDC. The hearing could not be concluded today and will continue on the next day. As agreed to by the party, this is matter on 25th. So 25th, next day after tomorrow,
Well,
for further hearing.
Another 3-4 hours. 45 minutes you have to reach.